Yes, Mr. Clark.
Lord, I would propose simply to pass to the second chapter
Yes,
of the submission, the meaning and effect of the contractual provisions. I'll come to the Charter Party very shortly, but I'd indicated that I would seek to do this in two sub-parts. The first part is to look very briefly at the approach to construction, and the main point I want to look at is just some cases, 2 or 3 cases, which deal with hold harmless clauses and broadly the intended effect of them. But if I could just make 3 short points then in relation to construction. First of all, the question of whether it's at all helpful to dictate the meaning and effect of the clause by characterising it as either an indemnity or an exclusion, and my short submission on that is that that's not the appropriate way to approach matters. One should give effect to the language in the clause. Although, as we discussed before lunch, my submission will be that it doesn't make any difference either in any event. The second point...
It's not necessarily an and/or question anyway, is it? It's doing, on your submission, 2 different jobs.
It's doing 2 different jobs, that's right. So it's absolutely right. It's not and/or. It can't be and/or given the language of it. The second point is simply, again, picking up on something we discussed before lunch, that it is important to have regard to the presumed intention of the parties to that contract, that is to say the present pursuers and ASCO, and for that purpose to leave out of consideration the interests of the defenders in this action. And one has to ask, was it the intention of the pursuers and ASCO that the pursuers could bring proceedings against ASCO, sue them to judgment and hold them liable in damages or expenses? And in my submission, this picks up from what Lord Hope said in the CRS case. That simply, it's very difficult to see why that is, why that could be the intention of the parties. What commercial purpose would it serve from the point of view of the present pursuers, or indeed from the point of view of the third party ASCO? So just that point, and then the third point, before I get to the actual language of the clause, is just to look at how clauses of this type have been discussed in the case law. And I don't intend to take up much time on this. It's enough, I think, just to look at probably 3 cases, one of them very briefly indeed. The first is the Caledonia North Sea case in tab 3. And there's useful material in the speech of Lord Bingham, where on page 10 of the bundle, he mentions in paragraph 1 the Piper Alpha conflagration which gave rise to the case. In paragraph 2, he says that operations to exploit the oil and natural gas resources of the North Sea have 2 prominent features. Basically, they are potentially hazardous, and secondly, they involve many contractors and subcontractors. And he says in paragraph 3, these features are not unique to North Sea oil exploration or exploitation. They're also to be found in the nuclear power industry. And he then says the regulatory regime is different, and he explains in paragraph 4 the regime for the nuclear power industry. And then he says at the end of that paragraph, essentially, that the licensee is given the strict liability, and there is to be no right of subrogation, and the standard forms of nuclear insurance contain a waiver of any subrogation rights. So essentially saying, in another dangerous industry with many parties involved, the statutory scheme is to say that the licensee is responsible. And he then says, he talks about waiver of subrogation, but he then says, here's when oil exploration began. He says that he talks about that in paragraph 5. And then in paragraph 7, he says, as would be expected, a market practice has developed to take account of the peculiar features of offshore operations. The standard practice during construction is described, and he mentions in the book, by Sharp.
This is sort of evidence, really, is it?
I'm simply saying, my Lord, that what he says here is, if one looks at the text on offshore oil and gas, this kind of arrangement is routine. So he discusses it there, basically the idea that an employer takes the responsibility for the injuries to his employees, even if caused by the other party. And he explains from another textbook, Dainty and Willoughby, how all of that arises. And then in paragraph 9, he refers to an American case where, again, there's the whole practice of mutual indemnities, etc. And just about 6 lines from the bottom on page 11, just part way along the line, then begins policy analysis. The purpose of the reciprocal indemnity arrangement in the Mesa Rowan Drill contract, as it is in so many similar oilfield service contracts, is to divide the responsibility for personal injury death among the many employers and contractors according to the identity of the injured employee, rather than according to which party's fault or negligence caused the injury. In effect, each party assumes the risk of the other's negligence and agrees to be responsible for injuries to his own employees, no matter how or by whom caused. The purpose of describing the classes of person in the indemnification provisions is to define those employees for whom each party assumes the risk. So he uses that as a background to discussing the first issue of construction and the second issue of subrogation. And we see in paragraph 32 on page 15 the relevant clauses in this case. And we see in particular in paragraph 32 that clause 15.1 says the contractor shall indemnify, hold harmless and defend, which is simply a different order from the words in the present case, the company and its parent, etc., respective employees, etc., etc. So it's a hold harmless indemnity. And then the clause goes on, as one sees, just about halfway down the paragraph, just above halfway down, to say, without prejudice to the foregoing generality, the contractor shall indemnify, hold harmless and defend, etc. So, this case involved those kind of hold harmless reciprocal arrangements, and Lord Hoffman discusses the effect of these.
Just looking at further down, I think it should be the contractor shall indemnify,
I think
not
it should be
indemnity,
indemnify.
hold harmless and defend the company and its parent,
Yeah.
etc., etc., from and against any claim, demand, cause of action, loss, expense, or liability.
Yeah.
The language in our clause is rather stronger because it refers expressly to the loss of the vessel.
Indeed, absolutely. And it's the particular clause is directed precisely at the loss of the vessel. That's right. So, against that background of these indemnities, Lord Hoffman at pages 21 and 22 says, first of all, in paragraph 81, the existence of the cross indemnity and the findings of industry practice made by the Lord Ordinary dispel any concern that it would be unreasonable to require the contractors to indemnify the operator against loss for which the contractors were not responsible. These are summarised in a passage in Dainty and Willoughby. That's the book which Lord Bingham mentioned. It's normal for the client and the contractor to assume, I think that should be full liability, and to give each other mutual indemnities, etc., etc. Paragraph 82, he says more than one reason is given for the practice. And then in paragraph 83, he says, senior counsel who appeared for the contractors pointed out that clause 15.1c does not embody the industry practice in its pure form because it contains the exception for the sole negligence or willful default of the party claiming indemnity. To that extent, it does not produce that clear-cut distribution of liability which the practice is intended to achieve. In my submission, that's quite an important observation. That is what these schemes are intended to achieve, as Lord Hoffman puts it, a clear-cut distribution of liability.
I'm not sure we need to go to this case to discover that.
No, I don't think we do, my Lord. I'm simply saying there is, it is put that way in this case. Again, the other cases are really not central or not essential to my position, but just to pick up a couple of points from them. In tab 11, there's the EE Caledonia Limited case.
Tab 11.
Tab
This
11.
case went to the Court of Appeal, where the appeal was dismissed.
I'm advised, my lord. I think again, just picking up on, this is really about the the Canada Steamships line of authority and whether one can be indemnified in respect of one's own negligence. But it's helpful to note that the clause is again the key clause in question on page 132 of the bundle. Clause 10b. Again, each party hereto shall indemnify, defend and hold harmless the other, a proviso about acting in good faith, etc. And one sees the rest of the language there. Now, that is actually about, in this example, it's about any injury to or death of any employee or damage, loss or destruction of any property of the indemnifying party. So, employees and property covered there. Now, what he says about it, Mr. Justice Hobhouse, at the bottom of the next page, 133, because the second part of the Article B, that's 10b, is mutual, in that it imposes indemnity obligations expressed in the same terms on each of the two parties in relation to the other. It doesn't refer expressly to any question of fault. The only words of causation are the concluding words resulting from, etc. Its subject matter is any loss of or damage to the property of the parties and any death of or injury to their employees. Its effect is that, in each case, the liability shall be borne by the owner of the property or the employer of the person killed or injured. And then, in relation to property, it has the effect of providing a defence to a claim by the other party. And then he says its effect in relation to death or personal injury. And in my submission, that is a quite correct characterisation. That the effect is, as he says, liability is borne by the owner of the property, and it's a defence to a claim. And just in relation to...
Well, I suppose that, against you, it could be said that this clause actually indemnifies against loss, expense or liability arising by reason of any damage, loss or destruction of property. So you indemnify, defend, hold harmless against loss and expense. That naturally means loss and expense incurred by the other party by the destruction of its own property. Whereas in the present clause, I don't see loss, indemnity against loss or expense. But there's a indemnity against claims, damages, liabilities, proceedings and causes of action resulting from loss or damage. So, I mean, one can take these verbal points, but I mean, your point would be that we must construe our contract.
Yes, indeed, Rob. Let's construe ours, and on its language, I would simply characterise it colloquially as pretty much a root and branch prevention of any liability coming into play on the part of the third party. But the allocation of risk point is dealt with on page 136 of the bundle. Just at letter G, where he says, it is always relevant to have in mind when construing a contract between commercial parties that the primary purpose of the relevant provision may simply be one of division of risk, often insurable risk. Thus, from a commercial point of view, it's perfectly sensible to construe Article 10b as a provision for the division of risk on a broadly knock-for-knock basis. And one, in fact, sees that expression used in a number of these oil industry cases. And again, in my submission, that's a perfectly correct characterisation of it. The risk is divided, liability is assumed by the owner of the property, and it's a knock-for-knock basis. And his lordship goes on to say there is no objection in principle to such provisions in the court, particularly a court accustomed to dealing with commercial contracts, should show no reluctance to give full effect to such a provision. And again, I would respectfully adopt that as being entirely the correct approach.
So where you have 33.5 and 33.6 side by side, that's what you say the position really is.
Yeah. It so happens in 10b in this contract they were encapsulated in the same provision. But what you've got when you look at the Charter Party is a whole set of cross.
Well, it's just a pity they didn't say clearly they shall not be liable in respect of any claim arising out of the loss of the vessel. They could have done, but chose not to for some reason.
Yeah.
If you have to express these things clearly, it'd be quite easy to do. For some reason, they did it in terms of indemnify and all that.
Yeah, yeah. Well, that's
Odd,
right.
really.
The language is there, but the question really is whether having not put in the additional language my Lord mentions, the overall effect of the clause is altered. And,
Of course, they lost here because they didn't refer to negligence.
That's right. Yeah. No, I take my Lord's point on that.
Well, presumably somebody drafts these and they have looked at the rather flowery traditional language and perhaps haven't thought it through entirely.
My recollection is in the Court of Appeal, I think it was Lord Justice Stane said, well, they must be taken to have read the cases and they'd have realised that if they wanted to exclude against negligence, they would have done so.
Actually, I think Mr. Justice Hobhouse makes the same point. Yeah, he makes the same point. The parties should understand the structure of the commercial law in that particular matter. So in tab 9, yeah, but Lanfran's just reminding me of where Mr. Justice Hobhouse refers to the point the point Lord Clark raises. I think it's at the top of 173.
Where are we gone? Where I had seen it was just on page 166, which just in the head note, what was held, and after paragraph 2 in the middle of page 166. Sorry, are we losing the bottom numbers or the top?
Sorry, my Lord, I'm using page 129 of the bundle. The top number 166,
Yes.
just in the middle of the page. Per curiam 1. Parties to commercial contracts must be taken to know the established principles of construction of contracts and to have drafted their contract, taking them into account. I think that's the point my Lord made, and it may have been made in the Court of Appeal.
Well, that's because these
as
contracts
well.
are drafted by lawyers usually, aren't they? I mean, or some legal department, one would hope,
Yeah.
but maybe they aren't always.
So,
It's access to legal advice is the way he puts it at page 173J. And in the context of
yeah,
established legal
yeah.
principles and so on.
yeah. Indeed.
And that's justice, he says.
Yes. So, all I take from the case is that it's an example of these provisions being viewed as it's put, knock-for-knock provisions, dividing the risk. There's a similar short point to be taken from the Diamond Offshore case in tab 9. I don't think I need to take up much time with it, but it's effectively a case in which one of the parties involved in the factual incidents of the case claimed to be covered by effectively the mutual hold harmless agreement and was held not to be covered. And we see that the plea in law. Well, in fact, before I get to that, just looking at what was held on page 110. As I say, just characterising it generally as a party saying, I'm actually covered by these cross indemnities, etc. Held that the defenders were not qualifying contractors within the bracketed part of 1711. There was a large gap between the bilateral indemnities offered in the defenders' agreement with T's agents and the multilateral indemnities contained in the pursuer's agreement with T. The terms of the defenders' charter did not qualify in the sense of knock for knock, and the pursuer should not be regarded as having given up the right to sue in delict a party with whom they had no contractual relationship, etc. So what was being said here was that the defender was claiming to be party to the mutual set of cross indemnities, but was held not to be, therefore didn't have the benefit of them, and was open to being sued. And as it's put, the pursuer should not be regarded as having given up the right to sue in delict. And when one sees the the clause, it's, well, first of all, I suppose before I get to the clause, just at the top of page 111, one sees in paragraph 3 that the sixth plea in law for the defenders was separatum esto, the pursuers have suffered any loss, injury or damage through the fault of Captain Bradbury, which is denied. The pursuers having agreed to indemnify and hold harmless the defenders in respect of such loss, injury or damage, decree of absolvitor should be pronounced. So the hold harmless clause is invoked as a complete defence to the action by this defender. As I've said, it's held that he doesn't have the benefit of it. The actual clause, I think one sees in paragraph 9 on the same page. And again, the language is slightly different from ours. It says that, save only provided in 17.4.2, the contractor shall bear all risk and responsibility for and shall indemnify and hold harmless the company in respect of any damage, loss or destruction of the rig, etc. So, simply an example of someone falling outside the scheme, and there was evidence led by, for a contract governed by English law, two eminent English silks. The reference to them is paragraph 12 on page 112. Gave evidence about the industry practice and the construction of the provisions, and they basically, I think the way the opinion proceeds is to say that the knock-for-knock arrangement. So, for example, I'm looking at page 113 in Roman numeral 5. The Lord Ordinary here says, I've had some doubts as to whether there has been adequate evidence before me as to the practice in the North Sea oil and gas industry as to directly enforceable third-party rights of indemnity to enable me to reach a view as to the existence of such a practice. As indicated earlier, the only evidence before me has come from two eminent English Queen's Counsel. They gave evidence as to their own experience in giving advice in the context of the North Sea oil and gas industry and to their knowledge of English law as far as it cast light on any such practice. Each referred me to the same passages in the speeches of Lord Bingham and Lord Hoffman in Caledonia.
So what are we getting out of all this?
What we're getting out of it, my Lord,
We're
is
not getting any question of law, our principle.
No, we're not. No.
This isn't a case of market practice, is it? So.
No. Well, I'm obliged, my Lord. I'm simply making the point that where these clauses have been the subject of discussion in the cases, they have been viewed as essentially knock-for-knock arrangements and indicating a division of risk and responsibility between the parties. That's the only point I make. But
I think it's so obvious from the face of clause 33 that it is along those lines because it says this one, that one, this one, that one.
Well, that was all I was referring to those cases for, my lords. If I can turn then to the language of the clause itself, this is really the final subpart of the second subpart of the second chapter and the last part of my submissions. Just to look at the meaning and effect of the clause. It's in tab 5, Roman 6 in the core bundle. And it's perhaps helpful to look, first of all, at page 136. This is the front sheet of the Charter Agreement, and just in special provisions, Charterers warrant to supply to owners names and identity of any offshore installation to which the vessel may be ordered prior to commencement of each service. Owners warrant to obtain blanket cross indemnities with such owners of these installations. So I just make the point that it seems to have been part of the scheme that there would be blanket cross indemnities with other parties. In terms of the relevant parts of the Charter Party, if I could turn next just to page 148, clause 18.1. This tells us what the owner is to provide. Now, A, B, C and D aren't directly relevant, but E is marine, war and protection and indemnity insurance on the vessel, together with such details thereof as the Charter may from time to time require. So the owner has to take out all of that insurance. And then the key set of mutual hold harmless arrangements is set out on page 154.
There's a passage at 149, isn't there? In little d, it's a sort of cross undertaking by the owner to indemnify and so on. Is that relevant, or is that just in relation to pilotage and mooring?
I think it's just in relation to pilotage and mooring, my lord. Yes, the 149 at D, there's the charterer has to provide pilotage and mooring and port facilities. Example, say the owner shall bear and accept responsibility for any loss, damage, expense or liability which it may incur and shall indemnify the charterer, etc., against any claim whatsoever may arise out of or in connection with the vessel's use of any pilotage, mooring, loading and discharging. So it does look as if it's restricted to,
Yes.
to those parts of the operations. There are certainly other uses of hold harmless and indemnify in other parts of the contract. For example, on page 150, just at letter H, this is about wrecks and or debris, and just in the second part of H on page 150, just about halfway down, the owner shall indemnify and hold harmless the charterer, etc., all liabilities of every kind and nature arising out of such wreck and or debris, howsoever caused. So there are...
So they can put in expenses when they want to.
Yes. But there are a number of different formulations. The Lord is absolutely right. They can put in expenses when they want to. But the principal section of the agreement is on page 154. It's clause 33, which we see headed exceptions oblique indemnities. Nothing much turns on that, but I just make the point that that they're not characterised by the parties in the contract as simply being indemnities.
Sorry, this is page 154.
Page 154, just at 33, my lord, just about halfway down the page.
Yes. Just the heading you're referring to.
Yeah, just the heading, although it actually comes up in 33.1 as well. Clauses 4, 6, 7, 18, 19 and 20, etc. shall be unaffected by the exceptions and indemnities set out in this clause 33.
Is the language of exception used specifically in any other part of the clause, or are all the clauses in the same form, namely the owner or the charterer shall, quote, defend, indemnify and hold harmless, ...
Yeah.
Is there any example of their using in the clause the language of exception other than in paragraph 33.1?
I think the answer to that, my lord, is no, because really the whole of 33 is about these hold harmless obligations. I'll just run through that, but it doesn't seem to me that there is any particular part of it that could be characterised as the exception part of clause 33.
Hold harmless runs right through the whole clause, doesn't it, repeatedly?
Yeah. It does, my lord, yes. And essentially, just following it through, 33.2 is about the charterer, as I would put it, taking responsibility for loss of or damage to the cargo. And 33.3 is the owner taking responsibility for death or illness or injury to any of the owner's personnel or anyone for whom he's responsible. And 33.4 is the mirror image of 33.3, charterer responsible for death or illness of the charterers or the affiliates of the customers, officers, employees. Then 33.5 is the key provision in the present case. The owner shall defend, indemnify and hold harmless the charterer, affiliates and customers from and against any and all claims, demands, liabilities, proceedings and causes of action resulting from loss or damage in relation to the vessel, including total loss, or property of the owner, including personal property of the owner's personnel, etc., irrespective of the cause, and then whether or not it's caused by the negligence of the charterer, etc. So that's the property responsibility, if you like, of the owner. 33.6 is basically the mirror image of that for the charterer. And then 33.7 may indeed hark back to the special provision. That's about The idea of this being that there will be mutual hold harmless indemnities in respect of property and personnel with the owner of any offshore installation. So the whole network is to extend that way. And then 53.8, I think, is really just extending making it clear that the indemnity to customers is fully stated, and 33.9 again is the mirror of that. 33.8 is the charterer as agent indemnifying the owners in relation to loss or damage to the customer's cargo, illness of the customer's employees, etc., damage to property. And 33.9 is effectively the mutual cross cover for that point. 33.10 is simply the charter as an agent, and 33.11 is about extending to consequential losses. So you've got all of that, and then in 34.1...
Why does 34.11 refer suddenly out of the blue to vessel owner?
34.11?
33.11.
Yeah, I think that's just one of the infelicities, as I see it in the agreement. It's owner is, I think, in any event, defined a.
But if owner is the same as owner, a vessel owner,
Yeah, there's no need.
then this is a good example of a clause, an exclusion clause, isn't it? Because and yet it uses the word defend, indemnify, and hold harmless.
Yeah, exactly.
It's clearly intended to exclude claims by the owner against the charterer for consequential or indirect losses.
And it is, as my Lord observes, and indeed I entirely adopt that point, it's the same language, defend, indemnify, and hold harmless. So it's...
The other point is 33.8, the charterer indemnifies the owner in respect of cargo claims by customers, right? It must follow, I mean, it can't sensibly be different, that under 33.2 and 33.6, the charterer is also excluding owner's liability in respect of cargo claims by the charterer, where the charterer happens to own the cargo. I mean, a scheme whereby you agree to indemnify the owner in respect of customers' claims, but
not your own,
hold him liable if it's your own cargo, it would not make sense.
It wouldn't make any sense.
And if 33.2 and 33.6 cover the charterer's own property, then you would argue 33.5 must cover, by parity of reasoning, the owner's own property.
Yeah, indeed, absolutely. And amount to an exclusion in respect of the damage to that property. That's right.
That's yes.
And it's difficult to think of any claims. I mean, how could you have I can understand an indemnity in respect of claims by owners' personnel, people for whom the owners are responsible. You need to indemnify the owners there. But if you're talking about the owner's own property, which this clause is also, how can you envisage the charterer becoming liable to a claim, demand, liability, proceeding or cause of action resulting from loss or damage to the owner's property? It's very difficult unless it's a claim by the owners.
Yes, indeed, indeed. So, in other words, one can, just to pick up that point, one can give all the content one needs to the word indemnify by saying that is in respect of other people's property. That's the point my Lord was making. But so far as the owner's property, it's difficult to see how indemnify actually, as it were, kicks in and deals with the situation. That's really, as I would have it, dealt with defend and hold harmless.
Well, perhaps they just haven't made it clear enough.
There's not much more that can be said, is there?
No. I don't really plan to say much more at all. All I was going to say was that there's some discussion before the Lord Ordinary of an American decision. I don't place any reliance on it, but your Lord Ordinary also refers to the Oxford English Dictionary and Black's Law Dictionary in relation to hold harmless. This is at, just briefly, at tab 5.4. Just in relation to hold harmless, page 72 of the bundle. Just at the end of paragraph 24, in the middle of the right-hand column on page 72, just towards the end, I had referred the Lord Ordinary to the Delaware case, where in a footnote the Vice-Chancellor hearing that case had said that basically looking at hold harmless and indemnify, while having similar if not identical meanings, are typically used in subtly different contexts. In the abstract, the word indemnify generally grants rights, and the phrase hold harmless generally limits liability. That's how it's put there. In paragraph 25, His Lordship goes on to deal with Black's Law Dictionary, hold harmless, to absolve another party from any responsibility for damage. And again, I would adopt that as being accurate. And then the Oxford English Dictionary, harmless, gives the meaning free from liability to pay for loss of damage, especially in the phrase to save harmless. So none of that is critical, but I simply say all.
So where was that?
Just over the top of the page.
Just over the top of the page, just from the bottom of page 72 on to 73, where the OED is referred to. And the OED definition is free from liability to pay for loss or damage. And that is bang on in terms of what my submission is, that the third party is free from liability to pay for.
I think the Latin for harmless is indemnis. I think it's just a translation.
Yeah.
Indemnis is harmless, and that's it's without loss. It's not it's damnum, loss, harm.
Harmless.
Indemnis is harmless.
Yeah.
That actually, the bottom of page 72 from Black's Law Dictionary. That's where it's put, I think, isn't it? There's in large capital letters, indemnify,
yeah.
to save harmless.
Also termed safe harmless. That's right. Yeah. Yeah. But as I say, I don't say that these turn anything in any particular direction. I simply say that if one has to look at hold harmless and try to give it some content, there's a basis for doing that. But the upshot of that is that in paragraph 26, the Lord Ordinary says this: the pursuers, by agreeing to defend, indemnify and hold harmless the third party from all liabilities resulting from damage in relation to the vessel, not only agreed to indemnify the third party against loss which it might incur from such liability to another, but also renounced any right to claim damages from the third party in the circumstances in this case. On that basis, the third party was not someone who, if sued, would be held liable. So, and in paragraph 27, he basically makes the point which we discussed just before lunch, that even if you simply say it's an indemnity, it doesn't actually make any difference. It amounts to the same elision of responsibility. Of course, the only other point I was going to make is simply the question of whether standing the terms of the contract, it can be said that ASCO, the third party, owed any duty in delict at all to the.
Well, that'd be a whole new case, wouldn't it?
I would have it that it's a point that wasn't developed below, but I would have it that it's simply an extension of the argument, effectively, and really all I'm saying is that you can either characterise the language of the clause as meaning that the parties simply did not intend that any action in delict would be raised, or you could simply say that it precludes the coming into existence of a duty of care, because ASCO, I have agreed with ASCO that I will defend, indemnify and hold it harmless from all causes of action and everything else. But Your Lordship's right, it's not a point that's been raised earlier in the case. And Your Lordship will see in the written case that I've relied on a couple of passages in the Henderson case, just really about the effect of the contract on the existence of a duty of care. But I don't need the point. It's an extra point. It's not a point raised below. It may indeed raise other issues. I simply say, if you take the wording in 33.5, viewed in its whole context, it was simply never intended that these pursuers would be able to sue the third party, and that if sued, the third party would be held liable in damages or expenses to these pursuers. And at the end of the day, it's a pretty short point, and I don't really intend to labour it, or indeed subject to just one question. Roger, I think in the course of the discussion this morning and thus far this afternoon, all of the points that I proposed to raise have been raised. Obviously, I'm in your Lordship's hands. Is there anything else you wish to raise with me?
No, thank you very much.
Obliged.
Mr. O'Brien? Yes, Mr. Howie.
My Lords, my Lords will be unsurprised to find that my motion to their Lordship's House is that they should adhere to the interlocutor pronounced.
He had anticipated that, yes.
I submit, my Lords, that, as my learned friend has indicated, there are two broad chapters potentially to this case. The first of them is to do with the interpretation of Section 3 of the 1940 Act. And the second of them is to deal with the interpretation or construction, to be placed correctly, on the Charter Party, in particular the indemnity clauses, or exceptions, oblique indemnity clauses of them. My learned friend treated of them in that order, and in the hope that it will be of some assistance to their Lordships, I propose simply to follow in his footsteps. At one stage in the discussion this morning, I believe the suggestion fell from my Lord Mance, that the issue in this case, as far as this section of the case was concerned, was primarily policy-driven. I respectfully adopt that and submit to their Lordships that what is called for in connection with the interpretation of this subsection, and in particular with the critical bit in subsection 3, subsection 2, is to consider the underlying reason for the right of relief and contribution to which it's giving effect, which is that it is, as the cases say, an equitable doctrine, and that therefore the interpretation to which, unless the court be driven otherwise, it should lean, is the one which serves to further the equitable purpose of according to each individual party who may have recourse to that subsection, the proportionate allocation of responsibility according to guilt for which it provided. That described in NCB against Thompson as the elementary idea that it had somehow taken till 1940 to provide in the law of Scotland. It is noticeable that the cases, and that one in particular, are strewn with references to the equitable doctrine, and indeed that the reason for the change in the law which was made in 1940 was to substitute for the previous pro rata distribution of responsibility one based on percentages of guilt, on the view that that was more equitable. Perhaps it was for such reasons that in the Inner House Lord Carloway placed the stress he did on the equitable issues. And in particular, in my submission, it's necessary to bear in mind that Section 3 has to deal with a whole gamut of potential cases, and not simply cases which arise in a commercial context against a background of contracts in all directions. It has to deal with, and indeed it may be that its normal application will be in connection with, cases in which there is simply a delictual relationship between the parties involved. In the court below, I
took leave to suggest the example of the humble road traffic accident. The three vehicles at the traffic lights who have nothing to do with each other until they both arrive at the same unfortunate moment at the same ill-fated set of lights. Section 3 has to be able to dispose of that case as well as this. If, in that case, it be the case that I imagine the driver in the small car, who is indeed in truth partly to blame for the accident, who is involved in an accident with a couple of vans, and unbeknownst to her, and of which she could know nothing, there is a contractual relationship between the owners of those two vans, in terms of which the other and guilty van is entitled to be indemnified by the innocent. In such a case, on my learned friend's thesis, if indeed contractual arrangements such as that can affect the outsider, I will use that phrase to avoid difficulties with the word third party in technical terms in Scotland, if they can affect that relationship and that person's rights to seek contribution, then in my submission there is a potential for saying that it is inequitable.
Sorry, just explain what the scenario is. We've got an innocent woman driving her car, and we've got two vans which have agreed to indemnify each other.
There are two vans which have agreed to indemnify each other.
One is guilty.
One is guilty, but one is innocent. The lady is guilty. But let's perhaps she's more sinned against than sinning. She is outside.
Which is it? The innocent van who's indemnifying the guilty?
The innocent van is indemnifying the guilty.
Yes. Yeah.
Now, in such a case as I submit, my lord, one has, if my learned friend's thesis be right, the ability for a voluntary contractual arrangement entered into between the two van companies to have serious and deleterious effects on the rights which otherwise the lady driver would have had to secure an allocation of responsibility as between her and the guilty van for the loss which they have both contrived to join together to produce.
Why is that?
Because if it be the case that a contract can serve to say that there is, let us say, the innocent van has said that it will exclude liability on the part of the company which owns the guilty van.
Why didn't you just sue the guilty van and get judgment against the guilty van?
Because on the hypothesis that I'm putting forward to their lordships, there is the contractual, for the moment what I will suppose, block on doing that in the shape of either the exclusion clause, or as my learned friend would have it, the indemnity clause, or whatever provision it be in the contractual arrangements between them that puts a stop to it.
We're only talking about C's loss, the innocent van's loss.
We're talking,
because, I mean,
yes.
the lady can clearly sue the guilty van for her own loss.
Yes, I'm leaving that entirely.
And maybe contributed negligence, but we're talking about distribution of C's loss. But it comes back to the same point. I mean, firstly, obviously, your appeal to the widow isn't really relevant when everybody has car insurance. But secondly, people who commit torts aren't entitled to expect that somebody else will be guilty.
I heard the point that my lord made about that this morning, and I freely accept that people don't go around committing torts on the basis that if there's somebody else there to share it with. Of course they don't. I accept that entirely. But in my submission, the legislation appears to have set up, and the common law before it, the notion that if such things happen, and in an imperfect world they do, then the distribution of the loss as between the relatively guilty parties will be, under reference to this contribution, enabled to be achieved on a basis which is proportionate to their respective degrees of guilt. That is done because it is supposed to be equitable that should happen. If an underlying contract of which my hypothetical lady driver can know nothing, cannot protect herself against, cannot arrange her own affairs by reference to contract to sort out, can have this effect, is that not the sort of very inequity that Lord Bingham was talking about in the 10th paragraph of CRS? I submit to my lords that the answer to that question is yes. though I suspect from my Lord's expression he may not be immediately persuaded of that.
Well, you have to pad it out a little bit more for real life. One's talking about a contractual arrangement that precedes the accident, isn't
Yes,
one?
of
I mean, I
course.
think it's accepted that you can't
Yes.
deal with this by entering into an arrangement afterwards.
Absolutely so.
So it's a slightly unusual thing. These two vans have a mutual relationship between each other, that if they happen to bang each other at this particular junction, they're going to have this accident. And then one wonders, well, how has this all come about? And you may end up with a situation not very different from the one we have in this case, where it's all part of a scheme which has been devised with reliefs and one thing and another. So, I mean, it's delightfully simple, and as presented, it's I could see the attraction of the equity, but in fact, you get into exploring the reality of the situation between the parties, don't you?
Well, my Lord, I submit that the reality of the parties, if one leaves out the underlying, whatever underlying insurance arrangements there's among them, for normally we set that on one side, and we say, right, let us look at the position of the respective parties. And if we simply look at that in my submission, I hope that the example is not all that unrealistic. I accept that in any given three-way accident at a set of traffic lights, the likelihood of an indemnity between two of the parties is fairly limited. That I grant. But one needs to make such a thing for the purposes of the comparison which has been made available to make the point about the equity which I'm seeking to demonstrate. And to demonstrate to their lordships that in such a case which may arrive, or any case in which the outsider doesn't have the opportunity to do anything about protecting his position by contractual terms, there is room for the inequity of which I venture to submit complaint can be made, and that if the construction for which it is contended on this side of the bar be correct, that is avoided. And that is avoided because, as I submit, if one looks at the phrase, who, if sued, might be held liable, and say that that is a position which is to obtain independently of voluntary actions on the part of pursuer and the potential third party, of which the defender in the middle can do nothing, then that is avoided, and as I submit, ultimately, justice is done all round.
So, I mean, this would mean that this has a swing side, doesn't it? It would mean if you look at the position, hypothesize the position on the assumption there's no contract, then if it was the contract which imposed a duty of care on the person in B's possession, you wouldn't be able to rely on that because you have to assume there's no voluntary arrangement. Is that right? So, I mean, in the present case, if the only reason for which Enviroco can be held liable is that it undertook contractual duties of care, if you say that the words "if sued might be held liable" require you to eliminate all voluntary aspects, then you eliminate the very contract on which in some contexts you'd be wanting to rely.
I'm not entirely sure I'm following this relationship, my Lord, because as I understand it, Enviroco is party to no contractual relationship with ASCO.
No, but
It will be with the...
Wasn't it employed by ASCO?
No, I believe it was employed by the chartering company, but for the hypothesis that...
I thought ASCO was the chartering company.
Sorry. I beg your pardon.
Yes, I think it was their instruction to clear the tanks.
Shipping company, I think.
That's
Lord,
why
bear
it's said
with
to
me.
be an affiliate. They're associated companies, and ASCO employed Enviroco, and the duty of care which Enviroco owed presumably arises out of that relationship, does it? Or it might in some circumstances arise out of that relationship.
If my Lord will bear with me a second.
Charterers have engaged the defenders to carry it out.
And the,
Sorry, I beg your pardon. I'm not cross purpose. His Lordship is correct. The arrangement is the contractual arrangement is between the ESCO company, the charter company, and Enviroco, the ship owner.
But I think
is the.
I'm looking at the averment at page
Farstad
81, Mr. Howie. Is that a fair way of looking at it? Page 81, page 8 of the record between B and C. The charterers engaged the defenders to carry out the work.
Yes, I had them the wrong way round.
And similarly, in the present case, if you're looking at the potential liability of ASCO, which is what you're relying on, that presumably arises in some way because of the charter relationship, does it?
It's not pled as such, my lord. It's pled exclusively as a delictual case.
Yes, I see. But in some cases it could. And if you eliminate all contractual aspects...
I'm surprised you can't dream up an implied term. I mean, it seems to me that what strikes me about this case is that there seems to have been very little investigation of the relationship between ASCO and their contractor. Because there must be some terms in this contract, and there must be quite a few, if there aren't any written ones, which are necessary to make it work.
May I put things...
I mean, the kind of allegations that have been made might very well have been pleaded in contract, but they haven't been.
I mean, the basic point is that if you're going to eliminate all contractual aspects, you may be eliminating things that you want actually to rely on, as in the present case, I think, certainly ASCO's responsibility, which is some sort of supervisory responsibility is said to arise.
Yes, it's under the guidelines.
Because they were the charterers.
Charterers and also the poor.
But anyway, I take the point.
Yeah. And equally, I see the observation my lord makes, because whether it's this case or not, my lord is entitled to test the matter on a theoretical basis, and plainly there is a class of case of which what my lord says would be true.
What's the answer, Mr. Howie, then, to the point?
Well, in that class of case, it would be, I think, necessary to accept on my part that there would not be a ground available, because one would be discounting. There would be a contractual case for which we say liability would be able to be sought. And then if you were saying one discounts any prior voluntary arrangement between the two for the purposes of determining whether or not they can be held liable, what I am talking about in this connection is discounting any voluntary arrangement between them which serves to mean that they would not be liable, i.e., I am not discounting the fact of the creation of the basis of liability. I'm suggesting that what is discounted is whatever it be is supposed to take them out.
So whatever takes people out, you just remove from the situation altogether.
Yes,
Seems
that's
to me
what
unreal and artificial world you would be entering.
It involves looking at the hypothesis that these things are taken out for this purpose. I accept that that can be described as artificial in the sense that it's about an underlying liability ignoring any question of the voluntary action as would happen, as I think has been common ground this morning, in the case of anything that were done after the accident. And that's plainly right for reasons that nobody challenges. And I submit that the voluntary action steps back from that in addition, because one has the same issue in essence about providing in advance that liability is to be in some way elided or excluded. And that has the same ability to affect deleteriously the interests of the outsider.
And can I just ask, I mean, what would happen under section 3.1 of the Act if both were sued at the same time? Supposing Farstad had sued both Enviroco and ASCO, can you apply the submission you just made in that situation under section 3.1, and if so, how?
The submission I have just made is a submission about what would apply in relation to subsection 3.2 because it is under 3.2 that someone may be brought in by a defender.
But
Under
that's not an
3.1
answer. But if the two subsections are obviously parallel with each other, covering different situations, is there any reason why subsection 3.2 should have a wider scope so that there's more right to contribution if only one person happens to be sued than there is if both are sued?
As I submit this, section 3.2 is interested in protecting the person who's supposed to be being protected, the beneficiary of subsection 3.2, is the contributing guilty party. Subsection 3, subsection 1 is about securing to the innocent pursuer a decree in solidum against anyone and everyone it can get it. It is therefore looking at a slightly different situation with a different potential beneficiary of it, if that's the appropriate word to use.
Is subsection 1 conceived in the interests of the pursuer? Is it not conceived in the interests of the parties who are called as defenders?
Let me respond. That, my lord, I see, but the distinction I'm seeking to put up is that the first subsection is one which is, as it were, controlled by the pursuer. It's what he does, whom he calls, whom he brings in, that enables one to talk about whether or not there'll be persons who are or are not, in the plural, found liable by the verdict of a jury or a judge. And then they are entitled, inter se, to a distribution of the relevant loss as between them.
But it's a condition to that entitlement that they are both found liable.
Yes,
Yes.
that I can't deny.
So there is no possibility of contribution under the statute in a situation where one of them has a complete defence under the contract.
Yes.
So if that's the case where they're both sued, why should it be different where only one of them is sued?
The suggestion that I make in response to that is that the difference has to be placed there in order to secure the underlying question of the policy of the equity for which I'm contending in relation to the person who can't get it. I recognise there's going to be some level of dissonance between these sections or subsections in that regard. And no doubt that's not always entirely desirable.
But if your policy was enacted, subsection 1 would be in completely different terms, wouldn't it?
I think you accept that, don't you? I mean, you just said that there's a dissonance, and I mean, that's the issue we've got to decide, whether it's really credible that the legislator should have said that you're worse off if you happen not to be sued than you are if you happen to be sued.
Or worse off the other way around, as I put it. In my submission, facts are going to fall out so that someone will always be worse off, and the question is going to be, as a matter of policy, what is the, if I may put it, default position of the law going to be? And that is indeed the function that falls to my
Could you
lords.
just explain, just so that I'm quite clear, supposing that Farstad had adopted the case against whatever they're called, the charters, ASCO,
Yes.
and had sought a joint and several decree against. That would then bring us into 3.1, as I understand it.
Yes.
Now, in that situation, would they have been able to obtain a decree against ASCO?
That jumps to some of the later points, but since my lord asks the question now, I'll seek to offer in one answer. In some respects, this depends on the construction of the clause which would be placed as being a defence. And if it were an exclusion clause, which were held to be valid, no doubt the answer to the question my lord posits is no. If it were an indemnity clause, then in my submission...
Well, let's just, I think we just leave it at the exclusion clause. Assume it is an exclusion clause. Your answer is, under 3.1, is no.
Yes, that's correct. They
And
can't.
that is,
And therefore no right of apportionment arises. No right of
Because
contribution arises.
there'll only be one person found
Yes.
liable,
Yes.
and therefore there'll be no one left to play the game with, as it were.
And then you ask the question, well, supposing the plaintiff, pursuer, very realistically realises that there's only one person who they can hold liable and sues that one person, you say that under 3.2, nonetheless, that one person can then recover contribution from the other person, who, if unrealistically that other person had been sued, would have had a complete defence and no liability to contribution.
Yes, and would, as I suggest, work out its remedies in that submission by reflecting its contractual rights, be it to indemnity or whatsoever, from the pursuer, so that the liabilities end up in the same
many
places.
cases there wouldn't be such contractual rights. I mean, there happen to be in this sort of
Yes.
scheme, but very often there
Accept
wouldn't be.
that must be right. I can't run away from it.
does it follow if it's an exclusion clause, there is in fact no dissonance between subsection 1 and subsection 2?
Yes, if it's a formal exclusion clause, because one cannot do other than say there is an exclusion of liability in such a class of case. There is no liability which can be found. That is, after all, the basis on which in the building contract fire cases, the fire insurance cases of which cooperative resale services was but the latest, the court held that there could not be findings and contribution under the English Act, because under the standard form building contract, as it obtained at the time of cooperative retail, and indeed its predecessors in Scottish Special Housing and British Telecom, which my Lord Roger may recall from the past, they all included a specified a complete exclusion of liability, as well as the exclusion of the indemnity, and therefore one had a situation in which there was no question of the main contractor being able to sue subcontractors, the employer being able to sue main contractors, because there were total exclusions of liability.
Can I take you back to your simple road accident case and just see where we stand in that situation? If the position had been that, as between the two vans, there was an exclusion clause, then that would have the effect we've just been discussing, would it? Even although the lady in the van the lady in the car wouldn't have known anything about this. The fact that it's a matter of contractual arrangement between the other parties doesn't matter.
I was, as I understood it, addressing a question put to me by my Lord Roger, which presupposes just imagine the section 3.1 action happens, and then you have to deal with a question of contract as between the parties to the two sides of the contract in the 3.1 action. And in that connection, I conceive I can't offer him any answer other than the one I did. And obviously, the answer that follows to the question my Lord puts to me is that, yes, that has to follow in that class of case. And that is indeed why it was accepted in the court below that if there were an exclusion clause and it were the case that the voluntary operations mattered, then I accepted that that would, like Mr. Blackburn, I accepted that that would see me out of the court.
Yes.
I got
I
told
see.
that maybe I shouldn't have done that, but that's why it was done.
Yes.
So have we got to this then at the moment, that if this clause was an exclusion clause, the appeal must be allowed?
I think only, as I understand it, only if we're talking of section 3.1 type situations. Am I wrong about that, or are you?
No, that's why I put to whether there was a dissonance between 3.1 and 3.2. I'd taken you on to 3.2, I'm afraid, although...
Are you
quite
extending?
rightly, Lord Roger's question was on a 3.1 point.
His question was certainly on section 3.1. Let me concentrate on section 3.2 for a moment in order that I may answer my Lord and my Lord Mance. The answer will be in my submission that either the submission has to continue to exist, or if my lords are persuaded of the view that it does not exist, that the two have to be the same and reflecting opposite sides of the candle, of the coin, then the answer to that will then be that it will follow that the appeal will be allowed as my Lord Clerk puts to me, because I will be stuck on the exclusion clause principle if it were held that this were an exclusion clause. There may be
On
another...
that basis, there's only one question in the appeal, and that is whether it's an exclusion clause. If it is, that's the end of it. If it isn't, then we consider what the position is if it's an indemnity clause, not an exclusion clause, but not an exclusion clause.
On that question, on that view of the case, yes, because my lords have, in essence, decided that no, I'm wrong about the voluntary point. Contracts do matter, and then the question is, pardon me, what is the nature of the contract they have before them, and is it an exclusion case, which would mean that you would not be in the statutory wording liable, or is it an indemnity clause in which you would be, as I would say, in the statutory wording liable? It's just that the ultimate financial destination of the money would be going somewhere else, and probably nobody sensibly would therefore try to sue about it, because it would be a bit of a self-defeating exercise.
You would say that if such a case came before the court with an indemnity clause between ASCO and Farstad, you say Farstad could obtain a decree.
Well, there is a curiosity lurking under this, which is that, as has been put a few moments ago, the person who is granting the indemnity here is the defined term owner with a capital O. I ignore the difference between that and vessel owner, which, like Lord Mance, I suspect is just the consequence of probably some taking of
Some other form.
terms from elsewhere, and somebody hasn't picked up that the drafting wasn't exactly the same. But the owner is defined as being at the beginning of tab 6, the owner is defined as being Farstad Shipping AS. That may be a mistake for ASA, given the drafting that one sees in the pleadings. But it's not the pursuer in this action. And so somehow or another, and I confess that I don't find it any easier than it appeared that my Lord Mance did this morning, or earlier this afternoon, to see how it would happen, that there could be somebody else attempting to sue for loss to the vessel, because there's no disponent owner here, and we're certainly not facing a mortgagee's claim, so it's hard to see what there would be. There seems to be something curious, but it's not the pursuer.
Well, the statement of facts and issue states in terms that the appellant was the owner of the...
Yes, I appreciate, I freely appreciate that, because it's a point that I, for one, noticed very, very late in the day, and I entirely accept that the statement says what it says, my Lord.
I mean, it's signed, the Charter Party agreement was signed on behalf of Farstad Supply, yes, owner. You see that at page 169 and so on.
Farstad Supply. Yes.
Yes.
The previous page, of course, it's Farstad Shipping. So there you are, that's all.
Yes.
It's all good fun.
Yes.
Yes.
And there's an issue someday, whoever wins this, coming about the consequences that may have in relation to damages. The passage which I had in mind in the pleadings, my Lord, is in the second article of the condescendence on the 6th page, indicating that...
what page in the bundle?
79, I beg my Lord's pardon.
Right.
It's the core bundle.
To the pursuers.
They chartered it from Farstad Shipping ASA, which at the time owned the vessel.
Yes.
And in 1998, on the 1st of January, ASA sold the vessel to the pursuer, which is a wholly owned
Charter's
subsidiary.
extended the period and the vessel remained on charter,
And
so there's
she-
obviously been a novation, hasn't there?
Well, I don't know. That may be the explanation, my Lord. Certainly something appears to have
You
happened.
wouldn't have been signing Charter Party addenda with extending the charter with Farstad Supply AS unless there'd been a novation.
One would have thought not, my Lord.
Described as owner.
Given, however, that they're companies in the same
This
group,
isn't the
who
point
knows?
that the defender has so far taken in this action.
No, it isn't. I entirely accept that, and just as I accept the benefit of the observation my Lord made to my learned friend about the last point he made in the new case, so I have to accept the criticism of the same point when it's directed at me about this.
Well, let's assume that the pursuers owned the vessel, and assume that they were party to this agreement, and assume that the term is an indemnity. Assume all those things, then would they be able to recover damages against ASCO if they sued in an action against ASCO?
That raises a question, or rather
Tell
an
me the answer
observation.
and then give me the reasoning.
Right. In my submission, the answer to that is that theoretically they could be held liable, but in truth they would not. And the reason for that, if I may now, with my Lord's permission, offer the reasoning, without appearing to be evasive, as I hope, is that there was an observation, I think, made by my Lord Mance and then adopted by my Lord Hope this morning about a Latin doctrine, frustra petis. And that might be the reason why, although an indemnity would mean that one would still theoretically have a liability to somebody, it simply wouldn't be pursued and decree wouldn't be granted, because it would be entirely pointless, and it might stand a defence by virtue of its pointlessness to grant decree on the liability.
So you mean that there never would be an order of the court ordering the defendant to pay, or ASCO rather, to pay damages to the owner?
I confess, my Lord, it is very difficult to see however it would happen.
But it couldn't happen. That doctrine is a very well-established doctrine in the law of Scotland.
Well, my Lord, I'm to stand to be educated by my Lord about that, because I venture to submit that it's not terribly easy to find security of action cases in Scotland at all, possibly because they weren't needed. The phrase comes, I have to recognise, in deference to my Lord Mance. I recognise entirely that there's a well-known shipping case called the Towerfield, in which the phrase is used by Lord Normand in this House in the 1950s, after he'd come here from being Lord President of the Court of Session. And I have also to accept, as my Lord Roger, I suspect, may be about to remind me, that appears, amongst other things, in Trainer as being the fundamental Latin basis for compensation, a doctrine which has been around in Scotland for a very long time indeed, and the existence of which may be why one finds very little in the way of reference to security of action in Scottish cases at all.
Could you just tell me how to spell the doctrine?
Oh.
I've never heard of the doctrine until very, very recently.
The first word is frustra, F-R-U-S-T-R-A. The next one is petis, P-E-T-I-S, which I think is the short form in which my Lord Mance mentioned it. It goes on...
Quod, Q-U-O-D.
It's a verb, isn't it? You seek in vain.
Restitutus.
Quod is
What?
Quod, Q-U-O-D. Restitutus, R-E-S-T-I-T-U-R-U-S. A's, E-S at the end. That's it. That will do.
I believe that there...
Various versions.
believe there's a version
Mox,
of
yes.
Mox appears in
M-O-X,
Mox.
Mox.
Yes, because
M-O-X
Mox is the critical
after.
word, yes.
Est, E-S-T, or
At the end,
Yes.
A's, E-S.
yes?
And Mox, where does
Mox comes in, Quod Mox.
What Mox says, restitutus.
Quod Mox Restitutus A's.
what Mox Restitutus says? Translation?
It is needless to seek to secure that which you must in the very short future give back. I'm sure my Lord, to
Vain
my Lord's
to do
right,
it,
can
is
give
you
a
do it
better
in
translation
vain.
than
You
that.
seek in vain what you're going to hand
Have to
back.
give back.
That's right. Which you're going to
Going
soon
to have to hang back.
hand back.
Sounds very like a security of action to me.
It is.
I can
Is security, I mean, it may be an irrelevant point, but we're talking about Scots law. When we talk of security action, whether in Scots terms or English terms, are we talking about a procedural or a substantive defence, in inverted commas?
compensation certainly is substantive, though it must be pleaded. And it's the usual form in which any of this would happen, because one would operate prima facie, if it were a contractual case, of retention first and then compensation once the two were liquidated. And therefore one would imagine that it would be conceived of as being in its compensation form substantive. If it were any wider form, one would have thought it is essentially procedural, because it is saying, as it says, one seeks in vain to recover that which you'll have to give back.
But
It's
it
not
does,
that-
it does entitle you to set up a defence.
Yes, absolutely.
I think my instinct, at any rate, was that this would be actually a matter of English law if it's because it's a substantive defence, but it may not. This being an English law charter, and one's
yes.
asking whether there is liability under an English law charter. But it may not matter.
Yes, I see my Lord's point. Certainly, I would immediately concede that the construction issues and so on must be English law issues.
Yeah.
That's quite obvious on the terms of the 48th clause of the Charter.
So on that footing, whether this is an exceptions clause or an indemnity clause, section 3, subsection 1 of the rate could never be satisfied. Because you'd never be able to have a case where, pursuant to the verdict of a jury or the judgment of a court, two or more persons were found jointly and severally liable in damages or expenses. Because you couldn't say that about ASCO, because they would have the defence of frustra petis.
That would be
Or
what,
applying English law, they'd have the defence of, well, on the truth
Security.
yes,
security.
I conceive it would be, well, I of course submit this with some diffidence to their lordships, but I could conceive it might well be circuity in England, but probably the net result will come to be very much the same as my Lord is putting to me. I should
the whole case.
well, that is on the assumption which I have put forward that my Lords are against me on the first point in relation to whether or not voluntary action counts for this purpose. If they're of the view that voluntary action counts for this purpose, and we're on to then considering whether or not this is an indemnity, then the argument which I address is one that there is theoretical liability, which I would have submitted is sufficient for my purposes for 3.2, but if my Lords are of the view that it has to reflect subsection 3, subsection 1, and whether or not there would ever be a day on which a decree would run against, I've forgotten who it is now, ASCO, I'm obliged, my Lord, ASCO, which would find them liable in damages or expenses, then given frustra petis, since it would doubtless in Scotland be given a Latinate name rather than circuity, then I would see that that would follow. I should, I suppose, to complete the exercise, indicate that when frustra petis appeared in the English courts, it appeared, I think, in, as well as the Towerfield, it subsequently was in the Post Office and Hampshire Council, where I think certain of English counsel, maybe certain of their lordships as well, who did not have an Admiralty background, were less than immediately enamoured of it, and I think it got described as an antique plea and various other curiosities. But in the course of the discussion of circuity, the same frustra petis material from the Towerfield appeared as well. So if my Lords see that as being equivalent to the Scottish frustra petis type compensation type of approach for compensation, or any wider case there may be in Scotland, then that would be it. I am bound to say...
Sorry to catch you before you move on. So, what is the English case for this? This came up. We haven't got it in the bundle.
Oh, no, my Lords don't, because I confess I had taken from the bit in which, is it my Lord himself or one of the other judges suggests that circuity is unlikely to be the solution to the problem. I didn't therefore trouble my Lords with them. There are two cases. I'm sure the citations can be found for my Lords. The first one is a shipping case called the Towerfield.
Towerfield.
Yeah.
It's all one word,
Yeah.
Tower and Field.
It's Workington Harbour and
Yes.
Dock Board
Yes,
against
that's-
Towerfield's 1951 appeal case is 112.
That is it,
Yes.
my Lord.
Yeah.
1951.
And the other one is Post
Post
Office
Office.
and Hampshire, which is 1981 QB
That is it
at
also.
124.
That is it also, my Lord.
My Lord likes to keep these in his head all the time.
No, I've got. I've.
It's 1951 appeal cases.
It's 1951 appeal cases 112.
Yes, I see. And a Scottish case in which frustra petis is mentioned.
The answer to that is not immediately. The place I mentioned where it appeared in Scotland, sorry, I should qualify that slightly. The place I said it appeared in Scotland is in Trainer's Latin Maxims,
yes.
as being what underlies the doctrine of compensation, with which, of course,
Yes.
my lords are so familiar I don't mention it at all. What I should say is that in what I hope was a fairly comprehensive hunt for references to circuity or any of its equivalents in Scottish cases other than compensation retention, which may be, as I say, the reason why you don't see it, I regret I could come across but one. There is a case referred to in Glogan Irvin in connection with the position of co-cationers as lying behind why it is that a co-cationer who comes along to sue one of his brother co-cationers, having acquired an assignation of the whole debt, having paid it all off, cannot recover more than that other co-cationer's proportionate share. And the reason that that is said to be, in this case, is that following, as I think my Lord Roger may be particularly entertained to learn, following a passage in Potier, it's said that the reason for doing this is to avoid a multiplicitous circle of actions, I think is the phrase that's used. It's not exactly the English terminology, but very close. Because each particular co-cationer could go along and do it to other ones the same amount of money, and you'd just chase each other around in your tail. That's a case by the name of Anderson against Dayton. It's a decision, I think, of Lord Kinnear. I may have the note for it.
Lord Kinnear?
Yes, Lord. I may have misremembered who the Lord Ordinary is, but I have the feeling that's who he is. And that is the only one I could find which appeared to deal in that, though, as I say, I freely recognise that the reason for that may well be the underlying and long-standing use of compensation and retention in Scotland to, in essence, avoid the problem for which, as I understand it, circuity in action was called into existence in England.
I think the Latin maxims referred to by McBride in Contract when he's dealing with compensation to explain the origin of it. So,
he's
but
probably
as I recall,
trainer.
he doesn't actually give any reference to its uses in cases in so many words.
No.
But the principle he takes back to that.
Yes, and I conceive he may have got that from Trainer, because certainly it's lurking in Trainer.
I see, yes.
It is to be found in some bit of Lord Kane's principles, not the bit, I think, which you've actually copied, or somebody's copied.
No, it's me. I do have to say that certainly it hasn't always been used in indemnity cases by any shape of imagination, because the reason that my lords find in the tabs the reference to the North of Scotland Hydro Board with the session papers, and in fact tab 16, it's only the session papers that appear, was that that is, as their lordships will no doubt be aware, having seen the references to this case in EE Caledonia and also seen it in the missing tab, was that this was a case where there was an attempt to recover on an indemnity clause, and the argument is the usual one about whether or not the contract is one which meets the Canada steamship type requirements in relation to negligence. But the reason that this appears is because what was being attempted to be recovered was some £5,164, 7 shillings and 10pence. And the reference to the closed record is for the 6th article on pages 8 to 9, which show how that sum was made up. And it demonstrates that part of what the pursuers are attempting to recover from the defenders on the indemnity is, amongst other things, the defenders' own judicial account in the previous action against them, which they had succeeded in getting. So this is somebody saying, perhaps because the point had been overlooked, but certainly this is one in which there's been no suggestion of circuity of action, because they're seeking to set out and recover the defender's judicial account. And of course, at first instance, they succeeded before the inner house said, you fail entirely on the construction point and this indemnity just doesn't cover this and this is all nonsense. But I thought it might be of interest to their lordships to see that certainly there had been no unanimity of consistency of use about this in relation to the Fruster Praetis doctrine, albeit that I quite accept the point made by my Lord Roger that given that it lies behind, my Lord Hope, that given that it lies behind compensation, it would in truth be common enough in disguise that we don't actually see it because we run straight normally to the compensation plea under the
It'd be lovely to
16th
see
Century
somebody
Act.
put it in so many words as a plea in law, wouldn't it? And that really would shake things up.
Yes, well, who knows, it may yet happen. After all, one of the observations which, though I suspect from some of the comments that have fallen from my lords, they may think I would be needlessly detaining their time, I was going to observe in relation to the defend, hold, harmless and indemnify material, being that it was all just repetitious and torrential, was that their lordships might be inclined a little to smile at a glorious indication of how the simple word indemnity covered what is usually meant to be covered by hold harmless, in addition, at least in the law of Scotland, in Lord Mackintosh's opinion in the North of Scotland hydro case, the missing one, where he observes that the purpose of the indemnity is to hold the indemnity scatheless. A wonderful phrase which I thought two of their lordships might appreciate as being a splendid homely Scots example of what is meant to be encompassed by indemnity and why it encompasses being held harmless in itself, and therefore means that the phraseology is simply duplicatory.
Well, is that a sequitur? It may be that an indemnity is a type of hold harmless clause, but it isn't necessarily the only type. If I agree literally to hold you harmless, i.e., I hold that you will not suffer harm. Why shouldn't that be as a result of my seeking to hold you responsible, which is certainly trying to harm you in legal terms? And that's the argument when you come to actually the wording of this clause on the narrow basis. And on the broad basis, the wording of these clauses, the argument is that the wording of these clauses intends a distribution of responsibility for loss, which is no doubt going to be matched by taking out of insurance, covered by taking out of insurance. And on the one hand, the charterers are responsible for their customers and it said their own cargo. On the other hand, the owners are responsible for their personnel, anyone else for whom they're responsible on the vessel, and for their property, the vessel included, including total loss. And those are the two arguments, it seems to me, you have to meet as a matter of pure construction. The narrow one and the slightly wider one.
The narrower one is to the effect that, as I understand, the
hold harmless is perfectly capable of embracing. We won't ourselves seek to harm you by holding you responsible for damaging our property or us.
The phraseology certainly is phraseology which doesn't have to be regarded as being duplicatory in connection with an indemnity. Of course, it is possible to have, I suppose, mere hold harmless without the words indemnity appearing at all. And that might have given constructions which would operate the other way and be said to encompass reimbursement and making whole the loss. I suppose it might also be sought to be said, and would doubtless be argued to be said against me, that it would form a sort of pactum de non petendo of the variety being postulated by my Lord Roger at an earlier stage in the discussion this morning. But in the present case, where one sees the phraseology defend, hold harmless and indemnify, in my submission, what that is postulating is simply a situation in which one is going to get the normal indemnity and not a penny piece is intended to be expended by the beneficiary of that indemnity in defending himself, or it will be at least made good to him subsequently. And no doubt the idea of a pending defend to it was in addition to secure that he would not have to spend his penny piece in the first place, because the person granting the indemnity would take over conduct of the action raised against him, say in the claim that's postulated for the liability later down the case. Now,
Well, that's fine
broader action.
if you're talking about third-party
Yeah.
proceedings. But
Yes.
here we're talking about, I will hold you harmless in relation to any claim for including total loss of my vessel.
Yes, my lord. And I think my Lord Mance has put to me already this
Yes.
afternoon the difficulty of saying, well, Mr. Harry, this is about loss to the vessel. Now, who is going to sue for loss of vessel? Who indeed has title to sue for any damage to a vessel? Now, everyone knows the number of people who have title to that is limited indeed. And
I mean, it goes a trifle wider, that it's a very odd clause which agrees to indemnify in respect of every conceivable sort of third-party claim relating to the owner's side, but doesn't purport to exclude liability in respect to the owner's own damage.
yes,
I mean,
This is the-
I'll stand behind you in respect of claims by all my personnel, anyone else for whom I'm responsible, but I reserve the right personally to hold you responsible to the ultimate. And as my lord says, who is it thinking about may be claiming in respect of the vessel then.
I think the only
Yes.
point really is that it would have been quite easy for them to make it absolutely plain as Pikestaff that this was intended to be an exclusion clause in relation to losses. There is a clause which refers to expenses. They didn't do that. The clause should be construed contra preferentum, and that's all there is to it. The difficulty is that too much focus has been attached to the expression liabilities, to my mind. I mean, what's happened here is that Farstad has promised to hold ASCO harmless against claims
On demands.
or demands. Yeah. So you never get to a liability. So there's never ever going to be, you're never going to get that far. And I rather think there is some authority about that, that claims does have an independent meaning in this type of clause, but I'm not sure that we've looked at it. But so it isn't just liabilities. If it were just liabilities, it would be easier from your point of view. But
certainly my position would be a great deal easier were it just liability.
Because one can always say that one's position would be easier if something had happened. I do follow that.
Equally, my lord, I can well see that there could be an intention that the mere matter of claim or demand could be intended to be different from a liability in respect that a claim or demand might be ill-founded, whereas by definition liability isn't. And one sees that, but if one is looking to say what is it that it was intended to be covered in here was to be the subject of someone who would be the indemnifier.
Well, any claim resulting from loss or damage in relation to the ship.
Yes, or the various bits of property, the various bits of personnel. One can imagine the master suing perhaps for some of his property which had been burned or some such, would be covered by it, and I think that's accepted on the other side of the bar. The difficulty which my lord asks me to face up to is, well, what about the vessel herself? And who is going to be able to sue for the loss of the vessel herself? And the answer presumably is her owners, whether or not that happens to be the person who is capital owner at the material time or not. There are in this case no disponent owners, but I suppose when this charter, which is a fairly long time charter, was entered into, it might have been in the back of somebody's mind that such a thing could come into existence at some point or another. But those are the possibilities, because presumably, and certainly upon the hypothesis postulated a little earlier in the discussion by my Lord Mance, that this was drafted with benefit of or access to legal advice, it must presumably have been intended to carry some general meaning. There were things that people had in mind as possibilities which they wanted to protect against.
But it's very bizarre that charterer's responsibility should depend upon whether or not the owners happen to be disponent owners and whether there's some head owner or not. Because if there's a head owner, then charterers are off the hook, you say if the owner happens to be the only owner of the ship, charterers are liable. Can I try it the other way round? Do you or do you not say under this contract that if charterers' cargo was on board, I don't know what sort of cargo is referred to here, it may be totally inappropriate for some sort of rig, isn't it? This
No, my lord,
submersible rig.
no, my lord, it's
Whiskey and cigarettes being taken out to supply the crew.
All right. One sees that there are all sorts of indemnities in respect of charterers' customers' cargo.
Yes.
Do you say that charterers could sue in respect of their own property under clause 33.2 or 33.6?
33.6.
33.8 makes quite clear that those clauses are intended to cover customers' cargo.
Yes, I assume that that is because it dates from before the 1999 Act in England about privity, and this was a scheme arranged together with the agency arrangement that one sees on the other side of the page to make sure that customers were supposed to be fully protected.
I think as was pointed out, I think the 1989 you mean rights under contracts?
Yes.
Doesn't apply to marine contracts, does it?
I had thought it was meant. It doesn't cover international ones, certainly. But
Anyway, this would be covered
But
by
this would be the
presumably
scheme, Himalaya or
might be a
something.
Himalaya
Yes.
cover, but anyway, 33.8 is belt and braces.
yes,
So does 33.2 and 33.6 allow the charterer to sue in respect of their own cargo?
yes, I think the position. I would suggest, my lords, that the position would come to be the same, where there would be an ability to sue. It would be entirely pointless, and one would get met with a defence that my lord has discussed with me earlier, because charterer must be always just the one person, and if he has cargo for which he sues and he's agreed to indemnify and hold harmless, then his action will be pointless, as my lord has pointed out to me earlier in the afternoon.
Then if that's right in respect of charterer's cargo, precisely the obverse must be right in respect of owner's ship under 33.5. It's the other side of the coin.
Yes, that is what one would expect, my lord, but the point to which I sought to call attention is the possibility that owner is not in fact the person who comes to be the owner of the vessel because of whatever changes in ownership there may have or may not have been, because unless this is assigned or novated or whatever else, owner will come to be, owner with a capital O, will come to be somebody else.
But owner in 33.5 is Farstad, and it covers Farstad's owner, just as charterer in 33.6 is a charterer, and it covers charterer's property. So if charterer's cargo claims are excluded under 33.6, owner's property claims must be, by parity of reasoning, excluded under 33.5. The obverse.
Yes, I quite see the point that my lord is making to be about obverses, and the reply, it's not for me to say answer to it, that I offer is that in the case of the charterer can only ever be the party who is party to this charter. The owner, however, of the vessel can be different from owner who is party to this, if only by accident. And in such a case, there might be some meaning could be afforded to 33.5, which would not be the same as the normal case.
In such a case, he wouldn't be bound by the contract. That would be entirely irrelevant to the discussion. But we are discussing rights and liabilities under this contract.
Yes.
In that context, could I ask you this? At the opening of clause 33 and at 33.1, one sees reference to both exceptions and indemnities. Is there a difference between the two?
I see no difference in the drafting throughout 33, as my lords indeed themselves pointed out when they were discussing this with my learned friend earlier on. The defend, hold harmless and indemnify wording appears throughout, and it does not appear, perhaps again it would be easier for me if it did, that there was drafting which could be said to be pointed to say, well look, there's a bit that's clear about exclusion or exception in these terms as opposed to something that is drawn in the language of indemnity. But I don't say that I can point to that because it's not there.
So what you would say is that you cannot identify anything in the body of clause 33 to which the word exceptions applies or is apposite.
There is nothing to which I can point that is to be distinguished from an indemnity by way of an exception.
Is that because the word exception isn't used again anywhere in the clause? I think I'm right in
yes,
saying it's used in clause 33.1, but not elsewhere.
It doesn't appear beyond 33.1, and 33.1 is meant to be a saving for certain other provisions, from which I would, of course, submit that if I have correctly characterised what follows, it means that the words exceptions and were a piece of surplusage that shouldn't really have been there. It is perhaps again a reflection of the way that charter parties are drafted.
There's never been a charter party without OTA's provision.
Certainly, my lords will see in the bundle there's reference to the Eurus, which is there for two purposes. One was to show that the general indemnity is against liability. That's the usual thing. That's why, as Lord Carraway puts it, indemnity postulates liability in the first place because you indemnify against something. And the other thing is that it also makes the point my Lord Clerk has just made to me, that the argument for redundancy is scarcely ever safe in commercial contracts, and certainly not in charter parties, which are notorious for having redundant drafting. And I would submit that that's just a bit of it, because it's been, perhaps because it's been picked up from somewhere else. The document's been being put together under some pressure of time, mayhap, and this is the kind of thing which is one is used to find happening.
Well, that argument cuts in every direction.
Of course,
Well,
yes, absolutely.
Well, that's the difference between the two of you. Mr. Clark says that clause 33 is there to do two jobs. One is to deal with third-party claims, the other is to deal with direct claims.
Yes.
You say it's only there to deal with one job, which is the indemnity job.
Indemnity job. My Lords, there was a little said earlier about the insurance provision in relation to this contract in 34. My short submission about that is that 34 is entirely neutral, because on my construction, just as I see the function it is meant to perform in my own friends, on my construction what it is there to do is to protect the ultimate financial destination of the monies and to secure that that isn't subverted by insurers or underwriters exercising subrogation rights. And so it comes to be entirely neutral in the dispute between my learned friend and myself.
Can it be, is it entirely neutral? Because on your construction, it can't be a waiver of all rights of subrogation, because charterers are liable for damaging to the ship, damage of the ship.
But I may be missing something, my Lord. The arrangement in 34 is about the owner taking out insurance
Yes, in
in
respect
respect of its liabilities under the Charter.
I see liabilities, yes, you emphasise that word when you say.
That takes you back to, what, 33.5 amongst other things, does it?
Yes.
Depends how you construe the word liabilities.
It does.
And
I see that.
and perhaps this next phrase, and shall obtain from its insurers a waiver of all rights of subrogation against the charterer and customers, was intended to include a waiver of subrogation rights in respect of property damage, but I see your point. If it's liabilities, that might not be.
rights of subrogation will be coextensive with the cover that this clause relates to.
I didn't quite pick up why you said it was entirely neutral. The initial proposition was
I beg
what
your
exactly?
pardon. The reason I contended that is because what the function it is there to perform, as I submit, is to ensure that the ultimate financial destination of the bill, if I can call it that, for the loss is not altered by reference to subrogation rights being exercised.
I mean, whose liabilities to whom? One wonders whether it doesn't actually mean responsibilities, because it doesn't make sense to, if it's liabilities to the Charter, which are the only
Yes.
liabilities which could arise under the Charter, then it doesn't make sense to talk about a waiver of rights of subrogation because
you wouldn't be going after
you
the
wouldn't have
Charter.
any if you were liable. So one rather suspects that this is dealing with something slightly different, and the most natural thing it would be dealing with would be to ensure anything which is your interest or responsibility under the Charter. And on one view, that would include liability, property, responsibility for your personnel's property, etc. But
i.e. liabilities equals risks.
yes, risks, exactly. And then you get a waiver of all rights of subrogation. All rights, whereas on your case, you might have to read that down a little. I suppose you would say, well, they aren't, if they've got a claim for property damage, then that isn't one of their risks which they have to insure against.
Correct.
So perhaps it's a circular point.
The claim is for what? It's for damage to the ship, and also there was some loss of life, was there?
There was, as a matter of fact.
What's the nature of that claim?
That claim does not appear in this case. I'm not entirely certain why. If my Lord's wish, I shall see if I can
So that
find
the
out.
loss claimed is all loss to the ship.
If my Lord will bear with me a second.
Article 5.
We're just told in general terms, I think in Article 8 of the Condescendence, that under the Commercial Court Protocol, full details of the claim have been provided.
It's quite Article 5.
Sorry, which article?
Article 5, seems 94. No, serious damage. Let's say serious damage.
There are lengthy averments, my Lord, in the 5th article and the 5th answer about the damages and the claim concerned. The claim that's made by Farstad is one about, in the main, it's about the damage to the vessel and the repair work that was required for the vessel. And then there is a claim for additional losses, loss of hire, consequential losses, which are then said to be set forth at some length in another document. And there are answers certainly
But
on...
it's essentially damage to the ship and consequential losses.
It's damage and consequential losses, and there is an argument of the type with which no doubt my Lord is not unfamiliar about whether or not the damages and the consequential losses truly are consequential and all sorts of other things. But that is
I think I didn't really want the detail, I just wanted...
the nature of the particular claim one is dealing in for this purpose. There was some...
Can I just ask, clause 33.11 shows, doesn't it, that the words defend, indemnify and hold harmless can amount to an exclusion of liability to the other party.
The expectation on this drafting must be in 3311 that in using the defend, indemnify and hold harmless wording, they are intending to seek to bar or exclude claims in respect of consequential indirect losses. It's difficult to see whatever else they could be doing in connection with 3311 A or B. It would seem to be rather pointless for them to be doing anything else in connection with consequential or indirect losses, because they're a class of loss for which presumably you're contemplating you're suing yourself at some point. It is noticeable, however, that in this connection one does not see the references, for example, to the liabilities of which I've been accused of concentrating over much already in this case, but it's noticeable that the drafting in the broader indemnity clause in 33.5 is rather different from 33.11, and that when one looks at what is done in 33.11, I think it is necessary that I should accept that the intention there must be to block heads of claim, because otherwise the drafting would make no sense.
Why doesn't clause 33.11 apply to the facts of this case?
On the indirect, the loss of hire of the vessel.
Consequential or indirect losses?
Yes. And you've got there
It certainly recovers to some of the losses.
consequential losses.
Some of the losses.
It would,
Yeah.
Whereas, and the question is whether the rest get within 33.5.
Fine.
Yeah.
Yeah.
So I suppose you can say, well, they used losses when they wanted to. They didn't do it in relation to direct losses. So the parties kind of intended the same provision, otherwise they would have so provided. And if they didn't, well, it's after contra proferendo.
and they chose, pardon me, my lord, they chose.
Get you so far,
Oh, of course. They chose not only that, but to add to that, they chose to do it in separate clauses on different pages. It's not as if it's all put together to cover the same thing in the one bit, as one has seen in some of the other cases
it
that
doesn't help you,
been
as my lord
canvassed.
pointed out a minute ago, really, on the meaning of defend, indemnify and hold harmless.
No, it doesn't, but I quite see that it's to be expected that parties would be using the same words to mean the same things in the same document. That's the normal drafting assumption, constructional assumption one makes in looking at drafting. But the very point that my lord has canvassed with me already this afternoon in connection with the manner in which charters are drawn up and whether drafting is entirely surplusage or redundant forever, seems also in my submission to hold good here too. One has to have a certain degree of caution about assuming that the drafting is entirely accurate, self-contained and pellucid, as I think was observed by Mr. Justice Staunton in the Eurus case I've mentioned already. It's quite evident that this contract was not drafted by a lawyer, at least not one who's from the Chancery Division, and I suspect this may not have been drafted by a pupil of that school either.
There's an interesting passage in 33.7, second line, where and it refers to mutual hold harmless indemnities. It sort of wraps it all up into a description of what an indemnity is about. Second line of 33.7.
Yes.
Yes, well, it's 4 o'clock. We have, I think, laid you to some extent. They have a large part of the ground.
I believe that's probably right, but I would
Are
feel
you
safe
able
in
to assist
checking
us
that
with
in the
how
morning.
much longer you think your submissions will?
I suspect a comparatively short time in the morning, but I shall check that overnight to make sure.
We should adjourn.